was a nightmare. I'm not going to say that. It was all pleasant, particularly when just one author was talking about it. Article 4 is not going to be a commentary because the author is not different. Nobody cares about that article.
Good afternoon, and thank you for attending the Meet the Author session organized by the WTO Library and the WTO Publications. Today we welcome the authors of the Commentaries on World Trade Law, issuing a second edition after a world acclaimed, at least by the lawyers, first edition like 10 years ago. We have Peter-Tobias Stoll, who is Professor of Public and Public International Law at the University of Göttingen. We have Holger Hestermeyer, who is a co-director of the Center of International Governance and Dispute Resolution and Professor of International and EU Law at the Dickson Poon School of Law at King's College, London. To discuss the book with them today, we welcome Jennifer Hillman, professor from practice at the Georgetown Law Center, and the world-renowned, at least at the WTO, Peter van den Bosch, director of studies at the Bern World Trade Institute. Thank you.
Thank you very much, Olivier. Thank you to the WTO to putting this wonderful panel together. Not only this, as we will explain in a second, the WTO has been also very instrumental in producing what we are presenting to you today, a publication in print and online on basically all the WTO rules in the format of a commentary. Holger and I are general editors to this project, and we will shortly today explain to you the content of this new publication, which is, as we say, starting to be published. So one volume is out, the others will come in due course, should I say. And then we would like to discuss with you, Jennifer, and with you, Peter, in what a kind of a context this reference work on WTO law will be published. So that will be a more general kind of a discussion which we have in a second. Before we do so, please let me also introduce you to some people which have been very instrumental to the whole publication. So, for instance, here we have Agata Dashko. She is the Assistant General Editor to the whole project, and later on will be available for giving you some details about the publication. And there we have Greg Messenger from Bristol, who is in charge for editing all the parts about the GATT agreement, which will be published very soon, should I say. So, and I'm sure that there are a lot of other authors here. We have Christian Pitchers, so we have the team around Giorgio Sacerdoti. I don't know who is here from his authoring team, so to speak, and I'm sure that some others will show up. But I think then now I hand over to Holger for giving you some information about the books.
Thank you. Is the microphone on? Yeah, okay. I want to start off with explaining what a commentary is, because I'm not entirely sure. First of all, there will be some non-lawyers here, And even for some lawyers, if you come, for example, from the US, you don't necessarily deal with commentaries. And I'll start with a basic experience that I do think everyone here will understand, which is Eugene Milligan's experience, and is the quotation with which John Jackson starts his Gut book. It is, anyone who reads Gut is likely to have his sanity impaired. And I'm pretty sure, and I have to say I have full admiration for everyone working in this building. I have pretty sure this is an experience that we all shared. Reading articles of the WTO agreements and thinking, what the hell were they thinking when they wrote this? This provision seems to make no sense, or at least my idea of what this does mean would destroy the whole system. That also makes no sense. And then you strive to understand the provisions. And this is precisely where things such as commentaries come in. They come from the continental legal tradition. And the idea is to have accessible information that explains to you every provision of a treaty, a constitution, a law. In this case, every provision of the WTO agreements. So even the ones that people don't usually speak about and that you read and you think, why has that not featured in the case? Because it does seem pertinent, but nobody ever mentions it and I don't understand why. And this is where you turn to a commentary. And the idea is that the commentary will not just give you the text of the provision, it will then explain to you how the text was drafted and what the drafters were thinking, and it then goes through how the text has been interpreted in practice, in dispute settlement, in the practice of the institution, but also in scholarly writing. And it will do so trying to reproduce the fullness of the interpretations that are available. So not focusing on just what the Appellate Body said, but if there is, for example, consistent criticism by scholars, it will also give you that. And it will then evaluate. And ideally, it will go through the provision step by step, word by word, prong by prong if there's a legal test in the provision, so that you can apply it in practice. Of course, it doesn't replace entirely other research, but as an entry point of all of those complicated provisions of WTO law, it is basically ideal. And you'll all know the analytical index of the WTO, where basically the WTO goes through the effort of taking the bits and pieces of dispute settlement and putting them under the provision so that they are readily accessible. But you also all know what the problem with that is. You still read that and you think, well, I was confused before, and now I'm confused at a higher level. The idea of a commentary is that it puts the interpretation in a context that makes it really understandable, and that once you've read the provision and the interpretation of the provision in the commentary, you truly understand what this is meant to do and what it did in the past. Now, the commentary series, as we put them out, currently has 6 volumes, so it's a rather large endeavor. It features more than 130 authors from around the world. It is formally a second edition, but actually more than 70% of the provisions are entirely rewritten, and a lot of the authors have been exchanged to have a more diverse authorship, to also truly represent the breadth of opinion that is available. And of course, that also means you can't vote individually for everything, but we have a very good central team. We go through everything. We've now spent 5 years on it. There were the pleasant moments, and there were also those that were slightly less pleasant. The 6 volumes currently are, the first one is Institutions and Dispute Settlement, so that would comment on the WTO agreement and on the DSU, but we've also tried to divide the topics in a way that they make sense as standalone books. So for example, the SPS and TBT volume will also feature, for example, Article 3 of the GUT, because you can't interpret SPS and TBT without that. That volume is out. The volume editor was Laura Wanner. The second volume is Trade in Goods and features, of course, heavily the GUT, but also the more exotic agreements. Customs valuation comes to mind. And that the volume editor is Gregory Messenger, who's here on the right. any complaints about late deliveries. By the way, that is also a problem, of course, that you have when editing commentaries, that every single provision needs to be commented on. So if an author delivers late, you cannot just drop the author, because you can't say, we decided that Article 1 of the GATT, for example, is not important enough to be commented on. Nobody would believe us. They all need to be in there, and that makes this, at times, painful. The third volume is Trade Remedies. That is more practitioner-focused, and you have a lot of trade remedy practitioners writing in that. It's co-edited by Kiliane Huigebart and Jin-Woo Kim in Brussels. The fourth volume is now in print. That is Technical Barriers and SPS Measures. And the editor of that is Markus Wagner, who teaches in Australia. The fifth volume, Trade and Services, Patrick Abel. And the sixth volume, the TRIPS Agreement, Chris Riffle. But another thing that makes the commentary special is that we decided not just to do the 6 volumes and have the print commentary, but also to have an online version that is hyperlinked, so that you have direct access to all of the WTO documents that are referred to. And we want to thank very much the WTO, because there was a huge technical effort going on in the background to make this a permanent thing, to make sure that not 2 years down the line you press the link and that link has disappeared because someone rearranged a database. And that is part of the work that I didn't even understand, but I'm just happy that it happened. On that as well, currently volume 1 and 4 are available, and it will be updated as the other volumes come along. Brill, I think, allows for 30-day trials. If you have any questions in that regard, Brill would be the right contact point. And so much about the project. Now, what we want to do is put the project into context with our 2 wonderful speakers, and for that I turn over back to Tobias.
Thank you, Holger, very much for explaining it so wonderfully, our project. And producing a 6-volume edition on the law of the WTO might come as something out of time when we see what's happening in the WTO, in particular, of course, the blockade of the Appellate Body. And here we are with 2 members of the Appellate Body. And the Appellate Body has been always considered to be the crown, the jewel of the WTO in bringing legal security and predictability to the multilateral trading system. And we know all this. And for both of you, I have 3 questions concerning this issue. First of all, what do we tell to international lawyers in other areas which never had an appeal procedure, so human rights, International Court of Justice, or something like this, why we are so specifically sorry to see the Appellate Body to come in a situation where it is not anymore functional? And secondly then, what do we say to political scientists which do say the problem with the Appellate Body is one issue, but isn't the failure of the Doha round the more critical issue in saying for having a functional rule of law system, you should also have some kind of a political power behind it, and the political arm is lacking. And the third, I think, goes more to the European side is, okay, if the Appellate Body is gone, why don't we bring enforcement of WTO rules through national courts by direct applicability of WTO law? I don't know, Jennifer or Peter, whom of you might go first, or whether you would like to distribute it a little bit between yourselves. And the idea that we would have this topic, and then we would also talk a little bit about regions in WTO law and practice, and about future trade lawyers. And after having done so, we would like then to involve or the audience here in a Q&A session. So perhaps, I don't know, Jennifer, would you like to,
Sure.
to start with?
Well, first, thank you very much, and it is really an honor for me to be here discussing this, and I will only give a little comment that I really appreciated what Holger said about trying to explain what this is, and I will tell that only from a personal standpoint. So very early in my career as a trade lawyer, I was the United States' negotiator on textile and clothing agreements. And so one of the first things I did coming into this job was to read the WTO agreement on textiles and clothing. And I had the exact same experience that you had. I immediately then turned to the long-standing U.S. government official who was our ambassador, if you will, here for textiles to say, okay, let's get out a good bottle of wine. Let's spend the entire day. I need you to go through this provision by provision because it makes no sense. I don't think I'm a stupid lawyer. I've read it 3 times. I've asked my husband, who's a very good lawyer, to read this, and neither one of us can figure it out. So we need a lot of time. So this commentary to me does, much more than the equivalent of my day-long encounter with Bob Shepard to kind of understand it. But my point is, it's really, really important for those that want to understand the WTO law to have something beyond the text and have something beyond the WTO, repertoire or other documents. And so I really do commend everyone for doing it. And the other part of it that to me is really cool is that it brings together the trade law family. So for those of you that are out there that are thinking about sort of careers in this space, get on a team to be one of the people that writes these commentaries. I mean, it is making you part of this trade family in a way that is really unique and very interesting. And to the extent that you use these commentaries, take a glance at who wrote them. I mean, just be aware of who this family is that you're sort of piggybacking on. So for me, it is really a wonderful thing to be involved in this project and for it to get the kind of use that it does. I'm going to start then with your first question. I mean, what does it say to international lawyers about why we are so concerned about the ending of the appellate body? And to me, it's 2 things. One relates to this commentary. That it was considered that what the appellate body said then became, if you will, I don't want to say the supreme law, but it became the first go-to place where if you were really trying to understand what was the meaning of a given provision, to the extent that there were appellate body decisions, that was considered the go-to place. And so you've now lost that because now you have maybe disparate panels that might slightly disagree with one another, and you don't have any sort of overall bringing of that together. But obviously, to me, the more substantive reason why there's concern is it now means, as we've seen, the vast majority of cases have been appealed into the void. Something that, to be honest, when the appellate body when the appellate body's demise occurred, I think there was a lot of optimism initially that it might be the United States that would appeal into the void, but everyone else in the world would say, oh, that is too dangerous a road to go down. We are not going to do that because it will really mean there is no longer any binding capacity within the WTO. We won't go down that road. And sure enough, the United States, of course, first out of the box, appeals into the void. But then, again, the European Union, to my surprise, immediately sort of following on. And then everyone else has gotten into the act to the point where I think only 2, maybe 3 decisions have not been appealed into the void. So to me, that is the real issue, is there another way to end up with a system that is actually binding in the absence of having an appellate body? And again, for me, interesting to think about. If you look at all of the other free trade agreements for the United States, the USMCA, and all of our others, all of the European Union agreements, they do not have a 2-tier system. They have a single-tier dispute settlement system. So it is interesting to think about, do you need an appellate body to have an effective international trade dispute settlement system? The argument, I think, if you look at all the regional agreements, would be no. Do you need it in the WTO as long as the rules say that you cannot have a report adopted by the dispute settlement body and becoming binding if there is a process of appeal? The answer is you've got to fix something. I mean, you've either got to change that rule about how you reach how you reach a reverse consensus to adopt a report, or you have to restore the appellate body. But you have to have a change in the rules. So, yeah, I mean, I do think there's a lot there, and I will then pass it on to let Peter comment on the other two questions.
Oh, I have something to say on the first question, too.
You are welcome.
Partly agreeing with you, partly disagreeing, but you would not be surprised about that. But let me start by congratulating the general editors of the Commentaries and their team. This is a huge, huge effort. I can't even start to imagine how difficult it has been to get all the authors to deliver in time, because if one does not deliver, you cannot. So congratulations. The commentaries, and that's a personal comment, and it goes along the same lines as the comment made by Jennifer, the commentaries have been very useful to me, both as an appellate body member and now as an academic. It's a sort of starting point. If you're confronted with a new issue, a new legal issue on the WTO law, where do you start? Well, commentaries are a good point to start. It's a very good point to start. Let it not be the end of your analysis, but it's a very good starting point. I was honored to be asked to contribute. So, and I think I was more or less on time. Well, Holger seems to remember that I was on time. So now, on the first question, what do we tell lawyers active in other fields of international law about the appellate body crisis? How much of a tragedy it is? Well, and that's wording I used in my farewell speech to the assembled WTO members. I think that WTO dispute settlement as a whole, and the WTO appellate body perhaps in particular, was a bold experiment with the rule of law in international relations. A bold and unique experiment. In terms of state-to-state dispute settlement, it went further than anybody had gone before. This experiment was not allowed to be, because as we all know, with the collapse, with the paralysis, I actually sanction my students when they say that the appellate body no longer exists. It does still exist. It's paralyzed. It's non-functional, but it does exist. But with the paralysis of the appellate body, the whole dispute settlement system has come to what I would call a de facto end. And like Jennifer, I remember the very early days of the crisis where you had ambassadors say, oh yes, it's really a pity that the appellate body is no longer functional, but we still have the panel stage and we will resolve disputes at that stage. Very well remember, I will not mention the country of that ambassador, but we had an ambassador of a big player at the WTI public conference, and this was the statement that he made. And I rose my hand and I said, really? Are you going to tell your minister that this is a report that went against us, and I could have blocked it becoming legally binding, but I did not? And this doesn't fly. So I was expecting that virtually all reports would be appealed into the void, and unfortunately I was right. So that's the first thing that you see, and that shows that dispute settlement is no longer really functional. The other thing that you see is a dramatic drop in requests for consultations. 7 this year. 7 is less than the worst year we had before the crisis. 2 years ago it was 5, last year it was 8, this year it is 7. Okay, the year is not over yet, yeah? But 7 is very, very low. And 5 of these 7 come from the European Union. So this is not really a system that is being used by the membership, and for good reason. Why would you invest in a panel stage? An investment you do in all sorts, political, financial. Why would you invest if whatever outcome there is going to be blocked? Yeah. So now, what do you see elsewhere look at investment law and investment dispute settlement. They're trying to create a system, and the European Union is in the forefront for that, create a system that provides for appellate review, and for good reason. So we have given up, we give up what others desperately want. And perhaps I will stop my comments here, and then I'll let Jennifer go first on the second question. Or do you want me to take the first?
No, it doesn't.
Okay, Jennifer.
Well, so your second question about what will political scientists say about, the failure of the Doha round, or how that feeds into it. I'm going to say I think it does, to some degree, to me, come from some of what Peter just said, because to me, part of the failure of the Doha round is a reflection of the lack of balance within the system. I mean, if you think about the WTO as a system, you arguably had three, some would maybe say four arms of the WTO. You had the negotiating function, and I think there's no question that the failure of the Doha round suggests that leg of the stool was either completely weak or literally broken off. You have the leg of the stool that is the executive function of the WTO, and some would say whether the committee structure fits within that or not. Where you have an executive function, you have the WTO Secretariat. I think everyone would agree is among the most competent, capable international servants you're ever going to find, but they fundamentally don't have any power in the system because it is a member-driven system. All proposals come from the bottom up. The WTO Secretariat does not have the right to suggest or recommend or push any given option or proposal. So at some level you have a very capable, but from a power structure basis, a weak executive. And then you had the judicial arm, which when the appellate body was functioning was perceived as very powerful, very successful, whatever else you wanted to call it. More disputes than anyone ever imagined, more appeals than anyone ever imagined. So whatever else you could say, the system was out of balance. I mean, there was no balance in the system. And so obviously two ways to restore the balance. One would have been the one you would have hoped for in the Doha round, which is to strengthen the negotiating function and potentially give more power to the executive. And instead, the response that the United States at least took was to push down the dispute settlements system so that maybe we have more balance, but it's balance at this non-functional level. All right, so as a political scientist, I mean, that I think is what you would have to look at is sort of the relative power structures. And it, to some degree, to me, feeds into this issue of whether this was an experiment and whether it was an experiment gone awry. Because from my perspective as an American, you think about it, okay, the United States does not join and does not accept the jurisdiction of the International Court of Justice, does not join and accept the jurisdiction of the International Criminal Court, does not join and does not accept jurisdiction of the Inter-American Court of Human Rights, on. Why then did the United States initially accept the jurisdiction of the WTO with a binding dispute settlement system? And if you go back and look at the congressional record as the United States adopted the Uruguay Round Agreements Act, which is the process in the United States to do that, you saw a lot of members of Congress saying, I don't like this dispute settlement system. This is giving up too much American sovereignty. I don't like it, but I really like that agriculture agreement. I really like this agreement on services. I really like the TRIPS agreement. And so a political balance was struck in the United States between giving up the sovereignty that it took to give up to get to a binding dispute settlement system in exchange for these other things. The problem with now trying to restore the system is there isn't any way to get that political balance going again. In other words, just flat out, do you want to restore the appellate body in exchange for what? Nothing. So it's a very difficult calculation, to see in the United States how we get back to where we were. I don't know that answers your political science question, but I'll let Peter then comment on the political science aspect of it.
I'm not sure whether I can do that either, but I completely agree with Jennifer that at the core of the crisis is, of course, the fact that there is an imbalance in the WTO system. That you have a non-functional, although one should be careful with that. But we talk about a non-functional rules-making system, a non-functional negotiating system. But what I tell my students always, yes, the Doha round didn't lead to anything, at least not as a whole, but there have been negotiating successes over the years. And we, I mean, we should also give the WTO credit for that. And MC12 shows again that agreements can be reached in this organization. Agreements that are not perfect, but that are pragmatic. And then I'm referring to the fishery subsidies agreement. Well, it doesn't actually address the most important fishery subsidy. But it's better to have that agreement, that incomplete, imperfect agreement, than no agreement at all. But what is shown here is that this organization is, if the stars are aligned, is able to come to agreement. So yes, there is an imbalance, and that imbalance has created enormous problems. Now, how do you fix that imbalance? Well, at the moment, they're fixing that imbalance by killing the other branch too. And then, of course, at the moment, we do not have an imbalance. That's not the way forward. The way forward is to fix the negotiating function. But we live in the world in which we live. And that world has become far more complicated than the world in which the WTO was created. Developing countries have found a voice. Developing countries that have not that much of a voice when the Uruguay-round agreements were negotiated. If I have to believe, and I am happy to believe them, as senior negotiators of the time, they said, well, at the end of the negotiations, we were told, take it or leave it. There were developing countries were told, take it or leave it, but you cannot really leave it, so you have to take it. So I think that developing countries has found a voice. We have also, we're now confronted with the geopolitical confrontation between the United States and China, which is a reflection of a confrontation between two very different, both political and economic systems. So it's not a surprise that it's very difficult to come to negotiated agreements, and it will remain very difficult. And I think we may find all sorts of ways, and we may write papers about how to overcome the difficulties of having successful negotiations. But the reality will be that in the next decades, it will be very, very difficult to come to agreements. Still, yet, we are able, from time to time, and on specific issues, to make progress. So, I'm not sure whether I told anything to the political scientists, except for, whatever happens will have to happen in the political reality of the day. The direct applicability of WTO law. Oh, Christ. As you may know, what now seems like a previous life, but I also worked at the European Court of Justice. That was actually an issue in those days. The WTO wasn't there yet, but the GATT, the direct applicability of the GATT was discussed, and at the time, I think correctly by the court rejected, with some exceptions, but rejected. When the issue came up again with the WTO, when the WTO was established and the issue came up again, the direct applicability of the direct effect of WTO law. I was honestly very disappointed initially when the court decided, nope, WTO cannot have direct effect in the European legal order. Because they basically gave two reasons. One reason was misguided, because they said, well, WTO law is a system. Is it really law? Because, I mean, you can buy non-compliance by agreeing to be subject to retaliation. And honestly, that was definitely a good argument in the GATT days, but not anymore in the WTO context, because their compliance is compulsory, and non-compliance, temporarily non-compliance, and accepting retaliation is a temporary remedy. The other reason for not accepting direct effect was, well, we can't put the European Union, then still community, we can't put them in that situation because the other major trading partners don't do it. So that would really put us, Europe, in a disadvantageous position. That I found an argument unworthy a Supreme Court. I mean, this is a political argument that they may have had in the back of their mind but should not have put on paper. Anyway, there have been advocates general who have argued more favorably for direct effect in the meantime. There has been some progress, but not very much. Obviously, and a former colleague of mine, Jacques Bourgeois, has argued very forcefully. Pete Eickhout has also argued for direct effect of WTO law. Yes, we have it in some member states with regard to some provisions of the TRIPS agreement, for example. They have direct effect. Yes, I mean, it would be all the better to be able to enforce WTO law in national courts, but I don't see this happening anytime soon, and certainly not as long as the United States doesn't do it. I think Europe will not want to do it. But you surprised me with that question, because I haven't talked about direct effect and direct applicability in a long time. But it's a very relevant question.
Well, thank you very much on this. Sometimes I think that it's a tragedy that we are talking for good cause today about so many individual rights developing in international law more generally. And we never talk about the rights of people who make their living, who develop their local conditions, who have a business, and who do investments, and who run into kind of trade barriers or something unexpected, which would ruin their business, make them to cause unemployment and misery. And so sometimes perhaps there might be need for fresh thinking in this area in the future. I think so. I think now we have discussed this issue quite extensively, and now I perhaps give on Holger to consider whether we should go into the issue of transparency or directly jump to the next question.
I think we should jump to the next question.
Here you go, Holger.
And the first question there, I think we already mentioned that this morning when I first saw you. It's something that occurred to us when we were working on the commentaries. Cultures are really, really different also in how they approach the provisions. And in international law, there is the joking trend to say we need a conflict of international laws because international law in the US is so different from international law in continental Europe, and international law in China is yet another thing. So, and it's supposed to be the same. And the same, of course, is true for WTO law. While we all share the set of rules, each culture seems to take a different approach to it. And we were wondering, to what extent is this regionalization of the same order relevant, and how can we counteract this trend of having different approaches to the same set of rules?
You know, it's such a good question, and it's always interesting to me coming from the United States, because we are so much the outlier in terms of both how does international law come into domestic law in the United States, and how is international law viewed in the United States, which is always interesting for those of us that are now, at least like me, more on the academic side. I always, when I teach just basic introduction to public international law, I always end up, you know, with these slides before my students in class showing all of the many, many, many treaties that are still waiting for the United States Senate to take up and ratify. And so, you know, part of it becomes this very interesting notion of the way in which international law comes into the United States that is very different, where, you know, again, our Constitution and our system, you know, basically puts such a supremacy in many ways over domestic law. I mean, in other words, international law only comes in to the extent that, again, a treaty is then formally adopted by a 2/3 vote of the Senate, and with our very dysfunctional Congress and our extremely dysfunctional Senate, how often does that happen? Almost never, I mean, these days. I mean, it's just very, very difficult. So then the issue is are there alternative ways in which international law comes into the U.S. system? And again, you don't need to hear all of the ways in which our courts have made it increasingly clear that no treaties are self-executing, so that everything requires an act of Congress to formally adopt whatever is international law, which again did not used to be the case many, many years ago, where much more it was considered international law was much more self-executing. It simply came into the United States in essence through the process of entering into agreements, and now it is much more this notion of, no, it has to be adopted by the Congress, which I will say in the trade realm, you know, kind of has its goods and its bads. If you look at how radically U.S. trade policy changed when the Trump administration came in, I mean, I would assume for many of our trading partners, this is just shock and horror that they thought that they had understood what U.S. trade policy was and what their rights and obligations were, and all of a sudden along comes the Trump administration, puts tariffs on steel and aluminum, and says, oh, this is a national security, you know, issue, and we're now saying to our longtime, you know, allies in NATO, no, you are a national security risk to the United States. Who thought this was going to be done? I mean, so all of a sudden you realize, you know, China, you end up with $360 billion worth of tariffs on your imports. Where did this come from? So you now start to see that there actually is a reason why the rest of the world needs to pay attention to what the Congress does and doesn't do, and how much of your rights you want to attach to the Congress versus how much of them you want to attach to the executive branch, if the executive branch is going to turn around and change every time there's an election in the United States. So I do think that aspect of sort of how international law comes into the United States is really different from the rest of the world, that it can just change really quickly as the result of an election, which I just do not think is as true, or put it this way, international law is not as volatile in many other places in the world as it is now in the United States.
Although, yes, I mean, just one comment on that further. I mean, perhaps the difference is not that big, because also in Europe, there is no direct effect, no direct applicability of WTO law. Yeah, so maybe a more difference in the willingness to express it as clearly as it is done in the United States. But on Holger's question about the difference in legal cultures or cultures of trade law, yeah, there are differences. And one of the great experiences for me sitting on the Appellate Body, or before that, 10 years before that, assisting Appellate Body members in coming to decisions as a member of the Secretariat of the Appellate Body, one of the great experiences was working with that difference. Yeah? because we do come from very different legal backgrounds. We have different legal cultures, different cultures, and the differences they manifest themselves in a number of ways. There are differences regarding to the role that law plays in society. Yeah? And there, Jennifer and I are very much on one line. Huh? For us, law is really focused on the rights and the interests of individuals. My Chinese colleague had a very different perception of law. Law is there to guarantee harmony in society. Yeah? So the individual is of a lesser importance. It's the society, it's the community that counts. And I don't carry a value judgment in that. Huh? And you say, well, but what does that have to do with trade law? No, it really trickles down to the way in which you look at trade law, at trade provisions of. There's a difference in the degree to which, in various legal cultures, you accept limits to sovereignty. Yeah, and Jennifer already hinted at that the willingness to accept limitations on sovereignty is much stronger in the United States. Not surprising, huh? If you're the biggest guy on the block. Huh? There's differences in the use of trade to achieve both economic and non-economic objectives. And I think definitely now the European Union, its trade policy is very much value-based. They try to, they weaponize, in a way, trade in order to achieve certain objectives. And that is also different from country to country. And it reflects in the legal culture. And then two other differences that I saw really played a role, and that made differences in opinion between appellate body members. I mean, obviously, we're not going to talk out of the deliberation because they're secret, but the difference in economic system, that underlies your legal culture, and the difference in political system. And just look around the table, and the seven, when there were still 7 appellate body members, there's quite a lot of difference. Yeah. Now, is this reason for concern? It's the reality. Yeah, you have to work with it, and you have to be aware of it, and that helps because that awareness and that understanding of the fact that people come from a different legal culture helps you to understand better what their position is and how you can come closer together.
That was the perfect segue to the last question before we open it up to the audience. Namely, well, the book is targeted at people who already deal to some extent with the WTO. Because that you need to be ready for the systems. You are both educators in Georgetown and the WTO. What do you think are the necessary competences that the next generation of trade lawyers need to have? What are the qualities that they need to bring to the table or try to work on to be capable of working in this environment?
Again, an excellent question, and I do see some young faces out there. Well, first, for me, it is to suggest that just because there is no appellate body right now, I shouldn't say there isn't one, the appellate body is no longer functioning, doesn't mean there isn't trade law and WTO law to be practiced. And so the first thing I obviously would say is you need some core competency in, if you will, the body of precedent that's out there, which is why, again, I come back to how important these commentaries are, because as the WTO system grew and grew, and the number of cases and the number of appellate body reports grew and grew, it is not possible for someone coming into this to simply read all of them and then come away with expertise, if you will, in the body of precedent. So again, for me, it is making sure you know the tools and the most effective, efficient tools to get to where you need to get in terms of understanding the precedent and what it means for you. And to me, that definitely is the commentary. The second one is I do think there is more of a need for understanding of administrative law than I would have said even 10 or 15 years ago. I mean, as we start to think about, is a CBAM, a carbon border adjustment mechanism, consistent with, and how do we do that? It really comes back to a lot of understanding it as a matter of domestic administrative law. How did we get to whatever this was? And I think across a whole lot of, whether it's SPS measures, TBT measures, to the extent that trade law has moved into behind-the-border measures, to me, that means understanding administrative law and understanding how those behind-the-border measures came into being as a matter of administrative law, and where that administrative law then sits within the bigger panoply of international law. Obviously, to me, you are now seeing trade entering other new realms, where some sense of understanding about the economics of trade, and again, where it sits in this geopolitical world is becoming more important, and where you can exclude or not exclude the geopolitics surrounding it becomes important. And last, I would say for all of you, it remains the case that you need to have some expertise in treaty interpretation. And so I don't think anyone should disregard the significance of just understanding the basics of the Vienna Convention on the Law of Treaties and other tools of treaty interpretation, because they will remain relevant no matter what sort of area of trade law you're in. Those are the skill sets and the tools that I think all of you young trade lawyers are going to need. And the other thing I will say is there's more trade law happening than we ever think about because of this growing number of regional trade agreements, this growing number, the whole movement that we're seeing to sort of rethink investment law and to maybe repudiate a number of bilateral investment treaties and rethink the investment regime. Across the broad panoply of international economic law, you're seeing real sea changes in the underlying treaties, which to me means the underlying skills of being able to interpret these new treaties remains really relevant.
Very happy to agree with everything you said. And so what I will be saying is partly repeating it, perhaps putting even more emphasis on some things. First of all, I think a good trade lawyer should know trade law in all its complexity. That lawyer should also be knowledgeable of other fields of international economic law and public international law generally. Why would you also want to have knowledge of other fields of international economic law? Well, for two reasons. First of all, there's sometimes great inspiration to be gotten in those other fields. Secondly, it improves your status on the job market. Law firms these days may not really be in the market for a trade lawyer, but they would be in the market for somebody who does trade law and also investment law and perhaps some competition law. Yeah? So that's the first thing. And be flexible as a trade lawyer, because otherwise you may not. Secondly, I think, and Jennifer already said this, but I would really want to emphasize this. I think a good trade lawyer should be well versed in economics. And this is something that is a short commercial. That is what we do at the WTI. At the WTI, we train our lawyers in economics. They hate it, yeah? But they're grateful after graduating. Well versed in economics, also in the political economy. And that goes to then geopolitics, because you can't understand why the rules are as they are without having that background. And then a few points that Jennifer has not raised, but I'm sure she would agree with them. I hope. First of all, a trade lawyer, a good trade lawyer, has to be an idealist. Yeah, but he or she has to be a pragmatic idealist. And a good trade lawyer should ask herself, himself, constantly the question whether she or he is really making a contribution to the common good. That's what I hope trade lawyers do, that they ask themselves that question. What am I doing for the common good? Yeah. It's perhaps easier to answer for lawyers that work in this building than for lawyers that work for private law firms, but ask that question. That's what I wish. And then the last thing, a good trade lawyer has to be an excellent communicator, because the story that you have to tell to the larger community is not an easy story to tell. Yeah. So that's asking for a lot, yeah? But I think that's what, these are the competences that a good trade lawyer should have.
Yes, Jennifer and Peter, thank you so much for that. And now we have quite some time still for kind of 2 or 3 or 4 interventions from the auditorium. There are any, because we touched upon quite a number of different issues. So if you would have any kind of comments or questions, we would be happy to address them. Yes, would you?
Thank you. You can hear me, right? Just taking a little confidence that you are here, really close related to the book, but you were talking about you make a question about the political science and lawyers and what we have to say to the rest of the professionals. In these times of change with the WTO and the Appellate Body and the blockade, and this change in policy in the USA, and I think it's also just changed the view of the whole world about how you can change your law and make some things that maybe before was not possible, or nobody dares to do it. What will be your opinion or your views in the balance that the WTO has to keep between the sovereignty of the states and this flexibility that can just affect the multilateral trade system, because there is always the question, where is the balance, where is the line between sovereignty and flexibility, because the times will change and change will be happening again and again. Thank you.
Jennifer, do you want to go first? Should I go first?
Yeah, go ahead.
The reason I'm passionate about trade law, and I hope that it's clear for everybody that I'm passionate about it. The reason why I'm passionate for trade law is because there's a constant challenge to find the right balance between, on the one hand, trade liberalization, and on the other hand, the legitimate pursuit of other core societal values and interests. And there is no magic solution to it. Yeah? I think the best that we've had so far, there's 2 approaches. Yeah? There's the approach of Article 20 of the GATT and Article 14 of the GATT, and all the case law that goes with it. That's one approach. And I think we've been pretty successful in following that approach. And the other approach is the approach of the TBT agreement, of the SPS agreement, where an explicit right is given to take measures to protect and so on. Yeah? So I think we have the instruments. The instruments would probably need to be applied more broadly. the fact that we do not have an Article 20 equivalent in the subsidies agreement is a great shortcoming. And I was fortunate enough to be on the division that was confronted with the fact that the TBT agreement didn't have an Article 20 equivalent. And so we were forced to invent the legitimate regulatory distinction test, for which, by the way, we're also criticized. But so, to some extent, the agreements allow for sufficient flexibility already, those that do not have this balancing in them. But this is the constant challenge. And again, it's a case-by-case looking for the proper balance. But
I would agree with all of that and only add, I think you see in today's world, if you will, a lot more complications coming where you're struggling with that balance. I mean, if you think about the WTO and mostly about the GATT system, you think that the core disciplines are really all about non-discrimination, whether that's natural treatment or MFN, and that natural treatment and MFN pervade also TBT, SBS, et cetera. Those are the core disciplines. And I think your question implies, and I think where the world is implying is that any longer enough? Or do we need to have as core disciplines anything connected to labor and labor rights, anything connected to the environment and environmental rights, anything connected to, and fill in the blank, whether, again, inclusiveness, gender, et cetera, whether a lot of what had been considered ancillary issues outside of those core disciplines now need to become core and central, and whether doing that, does it require new rules, or does it require, as Peter says, a different way to think about the flexibilities that are already in the system, and whether they allow for a different notion of what is the core central role and the core central, if you will, rules of the WTO system. You see it really clearly right now in all of the various climate change measures. I mean, can you put on a carbon border adjustment mechanism, et cetera, et cetera? They're all going to be about drawing that line between whether something is a legitimate climate change measure versus a protectionist measure. And where, who, and how that line gets drawn, again, is just simply getting more complicated as we move forward. And it's not, again, it's not just climate change, but it's in many of these other areas. And so to me, your question goes to that issue of whether what we need is just a more flexible way of interpreting to allow these other things to become core, or whether we actually need changes in the rules.
Thank you very much, Jennifer. And I think we have time to quickly take one other intervention.
Okay, it's super. Okay, I'll speak very loud and clear and very brief. So since we're discussing basically trade law and where it is right now, my question would be related to rising unilateralism and rising unilateral trade regulation. Reasons, of course, can be found, as we discussed, in the failure of the Doha round, DSM blockage, and many more. And for example, the EU has now taken a lot of new regulations, which are all unilateral, for example, due diligence in supply chains. And I wonder if from your expertise, based on your expertise and based on your opinion, do you think it is rather beneficial for trade law to have these kind of more new unilateral, innovative regulations, or is that rather a burden for multilateral trade law or even WTO reform?
Thank you so much to the panel for a very informative presentation. My name is Emmanuel Wachendo. I'm from the Institute of Economic Affairs, a think tank in Nairobi, Kenya. And my question actually builds on his question about sovereignty and liberalization, and a bit about something technical. So there was a very interesting article by Paul Krugman where he examined the same question, and I think he went through a commentary, and that's what got me interested in commentary. He said, look, yes, you can bend sovereignty and you can bend trade liberalization to a point, but you shouldn't break them. and he basically just wrapped it up with that, going through the political economy. So then my question was, given that, what in your experience, just even before they get to the gate and try to make those negotiations, what is your opinion about the negotiation capacity of different countries or regions around the world, and how that plays into how they consider the issue like sovereignty or trade liberalization? For example, are they more protectionist because they have weaker team of negotiators? So how does the bench actually contribute to their, if anything, to their orientation?
Shall I take the unilateral
Yeah,
question?
that one to me is
and
easy,
then
but
you
go ahead.
take the
Yeah. So you're taking the easy question, you're leaving me with the hard one. Okay, okay, I've been down this road before.
Well, we're negotiating again. On unilateralism, because that's the way I would translate your very good question, but let me give an answer that I can give. I think that unilateralism and unilateral action is not necessarily bad. Yeah? I mean, we should not forget that governments have an obligation to act when they see that interests of their citizens are endangered. If there is a problem with public health, if there is an environmental challenge, governments have to react. That's their obligation. And if that action cannot take the form of cooperation with others, they have to act unilaterally. So there's this little, and I think the European Union is a clear example of that. Huh? Now, at the same time, I believe that unilateral action is not the most effective way to address most problems. Everybody is aware of that, but governments nevertheless have to do something. So, the last point, if we look at the history of the GATT, and we look at the genesis of the WTO, it was multilateral action that made us progress. Yeah? And in that context, I refer to CBAM. We can discuss until the sun goes down whether CBAM, certainly in its final form, whether it will be WTO consistent, whether the European Union should have acted unilaterally. I don't think they had any choice, because it's their responsibility as a government to act. That's one. But what I welcome is the crisis that it will create, and the drive that it will be a catalyst for international negotiations on carbon border adjustment. And yes, in that sense, I think unilateral measures are both unavoidable and they may be the catalyst of international negotiations.
Then I'll take what I think is a harder and really interesting question on this issue of negotiating capacity. And I'll just say a couple things. One is, part of the ability to be a good negotiator comes from how much leverage do you have. And that has been, again, historically, if you look at it, one of the really difficult things for any smaller developing country. I mean, if you look at all of the rounds of trade liberalization that occurred, you know, the Tokyo round, the Kennedy round, all of the rounds leading up to the Uruguay round, for many developing countries, they lived and died by the MFN principle. Because if you think about it, you enter into negotiations with the United States, you don't have enough market to offer that would make it valuable for the United States to cut a single tariff on your behalf. There is nothing you can offer that would even register above an asterisk in the U.S.'s, you know, trade balances. So there's nothing that many developing countries could have to offer. So instead, you know, the leverage that the developing countries have is to live on MFN and to try to figure out whether there's another country or coalition that is going to be demanding market access in areas that are important. I mean, to me, this explains why agriculture has ended up where it's ended up, is because it was not subject to this kind of tariff cutting, reciprocal access, et cetera, because we didn't have any agreements on agriculture until the Uruguay round. So there has not been the leverage there, particularly in the way in which negotiations were conducted up until 1995. Now I think there is much more, as Peter has said. First of all, there's much more of a voice for developing countries than we've ever seen before. Secondly, I do think a lot of the other agreements, TBT, SPS, etc., do give more effective leverage, if you will, to negotiators. And the last thing I will say is the toolbox of support for negotiators is becoming much, much greater. For example, I'm now running this Center on Inclusive Trade and Development at Georgetown Law. One of the things that we have done is write handbooks on behalf of the United Nations, particularly UNSCAP, but they are now available online. So a negotiator that's looking to think about, how do I make my agreements more gender neutral, or at least to bring in more of a gender perspective, can literally go online and say, okay, I could predict this phrase, and it came from this agreement, here is the pro and here is the con. You're seeing it, for example, in the investment context, where, again, South Africa repudiated a lot of its bits. It then came forward with this SADC model with commentaries on, okay, if you want to keep MFN out of your investment treaties, here is the language that you could suggest. So there is a lot more. And for what it's worth, we may be putting together this database called TINA, that is a negotiators database, if you will, online through the United Nations, that would give every negotiator options. Pick this choice if this is what you want. Pick this language if this is what you want. So I think the toolbox that is going to become much more available to negotiators, in addition to all of the work that's being done under the Trade Facilitation Agreement, under Aid for Trade, under many, many of the education programs that are available, again, throughout the world for developing country negotiators. I do think we are arming the next generation of negotiators to have more in their toolbox.
And perhaps just to add to that, agree with everything that has been said. I think developing countries have, over the last almost 15 years now, have become much more efficient in pooling resources. Yeah. So I mean, many of developing countries have only a small mission here in Geneva, and back home they're not hundreds of SPS experts. Yeah, but there may be an SPS expert in the Colombian mission who can represent is not the correct technical word, but who can can follow the very, very detailed SPS discussions in the SPS committee. Yeah? So that pooling of resources has been described also in the literature. And if you talk to delegates of developing countries, they say, well, that works. Yeah? Because you don't have the resources to follow everything yourself. Our colleague Ujjal Bhatia has actually a book on that, which describes that process. Ujjal Bhatia. Ujjal Bhatia.
Thank you very much, everyone, for coming. Last words. If you were depressed that the world trade law was in decline, I think this showed it isn't. A couple of years back, I had the unfortunate coincidence that I left the Court of Justice of the European Union to join teaching in the UK, thinking, oh, I'm going to teach EU law. Well, turned out a little bit differently. But I can say that the WTO law classes, despite the Appellate Body being dormant, let's say, have gone up from 30 students to over 100 students. So there is a future for trade law. Thank you all very much for coming.